As many of you know, we have some big changes coming to the real estate world. I'm not exactly sure when this will be published, but August 17th is the date that the changes take effect. And Tosh has a really cool point of view because not only is he an attorney, he's also a realtor. So you're listening to the Landlording Show. I am your host, Tim Harstead. I'm a property manager in Chicagoland, specializing in C and D class properties. And this is the show where we go over the tactics on how to optimize your profit and optimize your stability of your investment properties. With me today, I have our first reoccurring guest from the law offices of Tosh Chandy. I have Tosh Chandy coming on to help us out again. Hey, Tosh, how's it going?
Good morning, Tim. Good to have you here.
Thank you. So we got some big changes in the real estate industry, and I guess I'll get the disclosure out of the way. As anything that we say today, I'm not an attorney, and Tosh is not your attorney. So please speak to attorneys on what you hear from here today, and make sure you're following your advice that you get from your attorney. But as many of you know, we have some big changes coming to the real estate world. I'm not exactly sure when this will be published, but August 17th is the date that the changes take effect. And Tosh has a really cool point of view because not only is he an attorney, he's also a realtor. So he's on both sides of these. And he also is on the Chicago Association of Realtors forms board. So he helped. We're going to talk about some of the new forms that are going to have to be signed. And he actually was there when they created it and heard the conversation they were having and the debates they were having. So we'll be able to dive into that. So, Tosh, do you want to give a little bit of a background of sort of just what the for people that haven't heard or haven't been paying attention, what this settlement and what the NAR lawsuit is?
Sure. So just to be clear, there was a class action lawsuit brought in a jurisdiction, I think, law firms in Kansas, I believe, Kansas or Kentucky. It's a firm that's small town Kansas they're famous for doing plaintiff litigation. They've had some large settlements. This is probably the largest settlement to date for them. And the basis of this is a group of brokerages were sued in a class action. And the essence behind it was there was no transparency on the way realtors were paid, especially on the buy side. Traditionally, as a listing agent, you charge a commission, which can range from anything you want. Quite frankly, it could be 1%, it could be 6%, but typically it's 5 to 6%. You offer a co-op commission to the buyer's agent via an MLS, which is usually half, or sometimes it's less, sometimes it's more. The buyer takes the liberty to hire their own realtor. They view properties, they write offers, and they get paid that percentage. What happens was nobody disclosed this usually to their buyers unless they had a buyer's broker agreement. It just went on like this for years. It was tradition. It was practice. A lot of buyers didn't know what's happening. They weren't sure if they were how the buyer, but they didn't care. They didn't have to pay it. They said, "Hey, great, I got a realtor showing me around." So they felt like this wasn't a transparent process, and quite frankly, I think there's some merit to that. But what has happened now is they've implemented. There was a large lawsuit. National Association of Realtors decided to settle the lawsuit. They could have appealed it. Quite frankly, they could have probably filed a Chapter 11 and tried to do away with this, but they did settle it, which it's a little confusing to me because they have a very good legal team and several legal teams. But they settled it, and this is a settlement, until two main points, two items. You can no longer state the cooperative commission on the MLS. So now when buyer's agent views the MLS, they see the property details, they will see nothing in relation to the compensation offered to them. Okay, so what do you have to do? You have to call the listing agent and say, are you offering a commission? Are you offering a commission? If they're not, they're not. All right, so that's one piece. The next piece is every buyer's agent will have to execute a buyer agreement, exclusive buyer agency agreement with their client. Some were doing this before, but now it's a far more complicated form from CAR. Of course, you don't have to use the CAR form. You can use your brokerage's form. But basically, this form will outline how you are to be paid as a buyer's agent. Are you going to be paid by your buyer? Are you going to be paid by the seller? And quite frankly, if you put an amount on there, say it's 2%, or say it's 2.5%, and the listing agent's only paying or offers to pay 3% higher, than what you agreed to, you can only get what the buyer told you. So that's limitation on that. So those are two forms. These changes are going to be implemented in our market. September? No, I'm saying August.
August 17th.
August 17th. There is actually a date in the settlement that I believe says September 16th. Somehow NAR decided to do this August 17th. And the hearing on the final judgment should be November 26th, I believe, right? 2024. And that's where
And I do apologize. We talked about this coming up later on, but you sort of just brought it up. This is the weirdest settlement, and maybe it's not. I'm not in law, so I don't know enough. But to me, it's really weird. They make a settlement. They agree to start doing the things in the settlement on August 17th. But we won't know until, you said November
26th.
November 26th if the settlement's valid.
Right.
So is is that something that's normal, and B, what happens if DOJ strikes it down?
The normalcy of that, because I don't do a lot of plaintiff work like that in class action suits. I do think implementing change in a large group like this before a date ensures that maybe everybody's up to speed. But I don't know if there's any nuanced details on why that was put that way. But I will mention, you and I spoke about the Department of Justice. It's interesting to see, you're saying, what are they going to do? And probably not going to do anything. I mean, the Department of Justice has a lot more to do than this. And, there's a presidential election, there's antitrust legislation right now going through. There's other cases that are more important. And the DOJ doesn't really insert themselves in a situation where there's already a large settlement. You know what I mean? So why would they take it on? So I don't think we have an issue on that end. That should be fine.
So we think it probably will pass, and these will be the new ways. So cool. So I want to jump in a couple of things first. I want to talk about being an investor and what's going to change. So one thing is, and I know a lot of investors want to see a lot of properties. A lot of investors, some work with one realtor and they have that realtor that's going to show them everything. And other investors are trying to go more direct, trying to go, they're going to work with whoever can get them in the property as quick as possible. It's just two different models. So for those types, the types that don't necessarily have one agent that they're relying on, I just want to touch base on what defines you as a buyer that's being represented versus being what's called a customer in the real estate world. So a lot of things have gone around saying, oh, you're going to have to sign a paperwork when you go in an open house. You're going to have to sign this and that. When exactly is a buyer going to have to sign something, I guess, is the best way to put the question.
Okay, so as an investor, because as a realtor, I still work with primarily investors, right, who are buying rehab. So this is how it usually works. They call me up and send a property to me via text that they saw on Zillow or Redfin, put offer on this, or, I want to look at this. At that point, I haven't worked with these people. I don't have a buyer's agreement with them. I mean, I've heard them for 4 years maybe. So now I will have to execute this buyer agency agreement with them. It could be for a day, it could be for a year, or for a month. Most likely I'll make it for 3 or 5 days. I'll execute that, and it has to be executed before I show them that property. Okay? Does it have to be a day before? People say it has to be 24 hours. No 24 hours in here, but it has to be before. That's the idea. So you could do that in the car. Okay? It doesn't matter. But you're going to do it online, or somehow you're going to get it done. After you do that, you view the property, you write the offer, you'll be compensated. That's how that will work. Now, if you are having an open house as a listing agent, somebody comes into that open house, they don't have a realtor, you're not going to be the dual agent, but do you have to execute a buyer agent's firm? No, you wouldn't have to execute with them. You don't represent them. You're representing a listing agent. You're opening a door, allowing access to a property, right? They didn't call you to view that property. They came in on their own, seeing an open house sign or seeing a listing online or an Instagram post. They can, hey, put an offer in and do what they want, and that's where it becomes a customer.
Well, what about going directly to a seller's agent? So you're listing. I see your listing. You got a house listed, beautiful house. I want to go see it. Instead of trying to work my own agent, I'm going to represent myself. When I call you, should I have to sign anything?
No.
Yeah. So I want to get that out there clearly, because I have a feeling that people are going to try to use. Unfortunately, there's some realtors that are going to try to use this as, oh no, you have to sign this. You have to try to lock you in for however long.
There's
try to see one of their properties.
There's still the concept of dual agency, so you can still be a dual agent. So you can still do it. So it depends on kind of what role you're going to play there and what role you want to play.
Yeah. Cool. So I'm going to jump in. We're going to talk about at least the Chicago Association of Realtors versions of these forms. Obviously, depending on where you're at, this is a national lawsuit. Depending where you're at, the forms are going to be a little bit different, but wanted to jump into the ones that we have access to here in Chicago. And the first thing, I'm going to jump around a little bit because I think the most important thing to discuss right now for the investor is compensation and sort of that shift.
Mm-hmm.
So when you're signing a buyer's agreement, now the big news article is that the compensation to your agent is going to be paid by you. And it can be true, but it isn't necessarily true because there's a lot of different variations of this.
Mm-hmm.
So I want to talk about that first. And I guess first off is discussing like, what does that look like to a buyer? So you sign an agreement, you're going to negotiate what your rate is, and then how does that look from there?
Okay, so in essence, we're referring to the buyer, the representation, this new form?
Yeah. So for a buyer paying commission, I guess is like, how does that? What are some of the ways that the buyers are going to actually pay commission? Obviously, one is just going to be that they're going to pay they're cash buyers and they're going to pay their own commission. But what are some of the other options that they have to try to pay that commission down?
Okay, so the way we have the form at CAR, and I'm not speaking on behalf of the Forms and Contracts Committee, but these are the new forms that are available on the website. So if you're a CAR member, you can download this to utilize it now, actually. There's pretty much three or four options. So they have three boxes you can check. There's one that says percentage commission, and in that box, you'd enter a percentage. So say you put in there 2.5%, okay, or you can put an amount. If you put that and you close on the transaction, as the buyer's agent, realtor, is entitled to the 2.5%. Now, if the seller's agent is paying the 2.5, the buyer doesn't have to pay it. Say the seller's agent is paying 2, you're going to owe the difference. You're going to owe the 0.5. For a simple example, $200,000 property, you should get $5,000 and give the buyer's agent. Say they're paying 2%, that's $4,000. So the $1,000 will have to come out of the buyer. Now, how will that work practically on a closing? Will they allow you to finance this? Probably not. So far, that's what it seems like Fannie Mae, Freddie Mac are not going to finance commissions. But you could use a seller credit, right? So part of your seller credit could go towards that. Or it's just going to go onto the settlement statement and your buyer's going to bring an extra $1,000 to the closing. I'm starting to do closing like this anyway. I've been doing this for about a year when this happens. And it's a rude awakening I'm going to tell these agents out here, keeping this a secret doesn't really make sense. Okay, so when you want to disclose this is up to you. I suggest you disclose it and explain it when you sign the form. That's why the form's here. But they don't explain it. And at the closing, the buyer says, well, wait a minute. It's a separate line, right? You have your two commissions. It's a separate line on the settlement statement. And it will say extra blah, 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 $1,400 to Coldwell Banker. I say, wait a minute. We paid the commission up top, right? No, this is your portion you're paying. Oh, I got to pay her extra? Why? I didn't know. So I'm breaking this bad news to some people, and they are kind of bent out of shape. But I told them, well, the realtor has a valid contract, and here it is, that you signed at the beginning. I don't think people even know what they're signing. And that's the irony of this lawsuit. We have this form. They still don't know what's going on.
No, exactly. So I want to touch base on that's the most interesting part of this, I think, as a realtor. So I'm a buyer. I sign a commission for 2%. Now you're my buyer's agent, right? You're going to call up because now again the rules are seller can still offer commission, but they can't list it. So now you have to take the extra time, and when you're doing the showing, call them and say, hey, what are you paying? So you call up and let's say that the listing the seller is paying 3%. My agreement says 2%. So now as a buyer's agent in the past, right? In the past, like, and we're recording this on August 1st. So as of right now, today, if we were to close as a buyer's agent, you're getting paid 3%.
Yeah, the 3%.
But how's that going to work? How's that going to work in the future?
The way the settlement reads is you can only get the maximum of what was on the agreement. So you will only get the 2%. You won't get 3%. So you can the maximum's capped at whatever you signed with your buyer's agent.
Gotcha.
So on this form, I want to mention, Tim, there are two other options at CAR. What's interesting, there's a flat rate. Okay, so the flat rate would be there, just a flat amount, and there's also an hourly rate, and it's billed in 15-minute increments. So you, as a buyer's agent, could say, hey, I'm charging $125 an hour. Now, what does that include? It could be doing showings, open houses. You can specify what you want to charge. There's also something on here that says a retainer fee. So similar, this is a new thing too. At least I haven't seen it. You could put $1,500 on here. I'm going to charge a $1,500 retainer. What is it for? You got to have an agreement with them. You just write a little writer, put on. There's a line there for additional compensation. Say, hey, it's a retainer to do showings, write an offer. So there's ways as realtors, you kind of got to figure out now what your business model is. It's not the business model is I drive around and I get paid from the seller's portion. You got to figure out how do you want to make your business.
Something, and I want to go back in a second. I'm going to stick on there, but I'm going to stick on that first. That's something to realize, that there is going to be a chance that you sign a piece of paper now as a buyer that says you're going to pay to go and see properties. So you have to be aware now as a buyer what you're signing and make sure you're reading it, because what you're signing, you could go look at houses for a month, decide, hey, the market sucks. I'm not going to buy anything, but still have to now pay that buyer's agent for their time, which, I mean, frankly, and like I said, you have the two roles. I couldn't imagine an attorney or a doctor being like, oh yeah, no, I'm not going to charge you for checking you out.
Let's talk about this. As you know, there are many real estate attorneys that only charge at closings. They don't charge anything, whether it's $550, $600, $650, $750. They charge us at the closing. And if you don't close, they don't charge. I personally decided I'm not going to follow that business model of my law firm. I think this is demeaning to the profession. Now, I won't say it's bad, and I'm not talking bad about other attorneys, but the way my retainer agreement reads is you pay a half deposit up front. I don't collect it all the time for clients where I get a little pushback, or realtors who don't like this model because they're used to dealing with investors or people who are used to not paying up front. So I don't push it all the time, and I charge at the closing. But if it does not close or it falls apart during attorney review, I still collect that initial deposit. That's what my agreement reads. I don't believe in doing all this work and writing attorney review letters, negotiating, and not getting paid. I just don't. And now, so as realtors, I think this is a good opportunity for you to explain to your client, hey, if you want to run around and drive around and just write offers left and right, you can. If you want to have somebody qualified to guide you through the process, this is what I charge, right? I charge 3%. And if they're going to pay me 2%, you're going to owe me the 1%. You know what I mean? There needs to be a lot of knowledge and a lot of education that has to come with that.
And I think we're going to see a lot of changes. I don't think it's all going to be right away. I think the industry is going to transform. And I have a prediction that, and we've talked about this, there's probably way too many realtors in the world. There's a lot of people that are realtors that aren't full time. And I think that we won't get into other things that NAR should get sued for, but that's something that they should get rid of. There's other professions that if you're not working 30 or 40 hours in that profession, you're not qualified. But yet in America, we let the biggest purchase of most people's lives be dictated and ran by someone that's, working 1 hour a week.
The reason, quite frankly, I was a realtor for over 15 years. Well, now it's about 15 years, but I was a realtor for about 8, 9 years before I became an attorney. And there are individuals who still call me now, even new individuals who I've represented as an attorney who call me to be the realtor because they know I have knowledge. I keep up on the knowledge of the area, the market, and the markets that I work, right? Pricing, what's going on in those areas, what's going on with zoning, how do you deal with land issues and surveys. They know I have that knowledge. They're not calling me because they don't have anybody else to write an offer. They could go to the listing agent and write that up. But there's value I'm bringing. It's not just, oh, Tosh, write up an offer. You know what I mean? They know he's going to give me all this other feedback. It's not just to scribble his name on a paper, right? So I think if you're valuable to your client, they'll use you and they'll compensate you.
And I agree with that. And I think that's something that, as for the consumers, I think that they should be pushing for is, if your realtor's not giving you value outside of opening a door for you,
right,
that's not the realtor you should be working for. And I think this case should open up some eyes for people that, hey, a realtor's job is to be able to run numbers, tell you where the deficiencies are. And we'll get into the agreement a little bit later. So there's some interesting things there that I'm like, yes or no on. But one of the things I wanted to say really quick, and I'm going backwards because we got a little bit away from it because we had some things that came up, but we were talking about you signing an agreement for 2.5% and the seller's paying 3%. Here's something to keep in mind with that is if you find out that information, that's good information to know because, and your realtor should be helping you with this. You already know that seller is willing to give another 0.5% discount. So if and you can use that if it's a multiple offer situation, hey, I don't need any of your money. or you can use it as a tool to get a bigger discount, being like, you already agreed to give 3% to the buyer's agent. You're only going to give 2% to my buyer's agent, so we want a 1% discount. So I think that's something that you need to be aware of, and talk to your agent about, okay, what commission is this seller offering? Not what are you going to get? I know you're going to get whatever I said, but what are they offering? Because that's going to help in the negotiations.
That's a good point. Yeah, and I don't know if that's being lost in this discussion. I haven't heard anybody bring that up. But you're right. If you're a savvy individual, you'll look into that, right? Because that might be a whole percent, and on a $400,000,
exactly,
that's $4,000 of leverage.
Yeah, exactly. So it's always good to have leverage.
You had mentioned with investors, how does this come into play with them? Also, I want to bring up on this forum, they're trying to now implement this change where they're very specific. So as investors probably just, they call up a realtor and, hey, can you go show this? Maybe somebody said, hey, I know a realtor, he goes church. Oh, okay. Yeah. Call him up. Now, here's the thing. If you're working with someone and you're not locked in, it's fine. But say you fill this out and you put on here Chicago, city of Chicago. This form's not valid for him showing you that single family in Orland Park. Now you could say it is.
That's a good point. Yeah.
It's not going to work. Technically, it's not valid. So if the buyer says, well, I didn't tell you that. I didn't say you're getting compensated. Thanks for, you should have thought about that. So you got to be specific on this form, or just put, all areas. But that's something you got to think about an investor. Am I going to use a realtor and stick with them, or I just plan to use different people and fill the form accordingly?
And to be frank, and I'm gonna say this: there's 10% of our realtors are really good, and maybe 20%. And again, I don't want to. It is the fact. Like there's thousands of realtors, and there's maybe hundreds that are actually at the meetings, the car meetings, and stuff like that. That are trying to make the field better. And to be frank, at this point, the way that it works now, because the seller's going to save money now. If you are unrepresented, you can get a better deal. So obviously, I'm going to tell you that if you're working with one of the top realtors that actually is good at their game and is helping you negotiate better, they're worth more than 3%, 100%. But if you're just calling whatever realtor, you're on Zillow and I want to see this house, give me whatever realtor you pick.
Right.
At that point, call the listing agent and be unrepresented. You're going to save 3% from the seller, and that's a negotiation tactic. You're going to get a better deal.
That's what we're going to see for more savvy buyers or repeat buyers, investors. I don't understand in what world they'll use a realtor on the buy side. I don't see it happening. And I hate to say this, it's not negative, but like myself, if I'm going to buy an investment 2-flat and I see it listed, I'm going to call that guy and say, here, blah, blah, blah. I look at it. Here's my offer.
Exactly. And I think that's
in my mind, I'm going to offer 3%, 2.5%, 3% less to start. That's going to be
I'm going to say that, like, I'm going to openly say,
that's common sense. Yeah.
Hey, here's the full price offer. However, your 3% commission that you were going to pay an agent if I had it, I want that as a credit.
And
or, you're going to write.
Yeah, well, they'll explain that to their sellers. They'll explain that, hey, you know what, this offer is here. If you came with a realtor, you'd be out another. So, I mean, that's makes sense.
So I want to go over a couple more points on the buyer broker representation agreement. One, and this is on both of them, but this is a fun little one that are on all the forms now. This contract is intended to be a binding real estate contract. This contract is not a government specified. Why can't I say that word? Form. The brokerage and buyer may negotiate any of the terms of this contract before signing. Brokerage commissions are formulated and not set by law and are fully negotiable prior to execution of this contract. So this has always been the case. However, now we're going to put it at the top of every form.
Not to interrupt, but that last line is actual language from the settlement. That last line?
Yeah. So I think a lot of people thought that I had to pay 5% or I had to pay 6% or whatever their community was when they list a property or when they're buying a property. Look, And again, if you have a good realtor, pay them what they're worth. I'm going to keep saying that over and over as a reminder. But if you're getting the new kid on the block, or if you're getting a brokerage that is a discounted brokerage and not doing everything, or only doing minimum services, which is on here as well, what that is, basically writing offers, presenting offers, and showing you a few properties, that there's no, negotiate with them, beat them down as an investor, you're going to get a bigger discount. And you're going to be able to use that discount to save money on the property. So I don't think the non-savvy buyer is going to see a reduction in pricing. Like when this lawsuit first hit, everyone's like, housing's going to get so much cheaper. I don't think for a non-savvy buyer, it will. But I think that if you're a savvy buyer, it 100% will. You'll be able to negotiate better and have higher leverage if you're using these the right way.
I think that's true, but when you say you don't think prices will go down, I think in a lot of our areas you'll see a little bit of price reduction. I don't know if it'll be noticeable, like where we'll say, "Oh, okay, wow, this area is now down a whole %," but there will be. I think some of the prices will. They may not come down from last year, but I mean, maybe they won't grow as much, right?
Maybe they won't grow as much. I will say this. So I just read an article on Bigger Pockets that the feds are now predicted to drop rates in September.
Yeah, about 100%.
Which is right around the time where we'll have a couple weeks into this and we'll be seeing stuff. So you're going to have one force raising prices and one force lowering prices a little bit. So it may be in the math, but I don't think we'll ever be able to pick it out.
Yeah, and then that interest rate drop, I mean, there's going to be a lag time with that too. By the time that works its way out, it might be 2-3 months.
So here's something that I find interesting, and I just want your opinion on it. On this buyer, this is on page 2, but limitations on buyers' designated agent duties. Number G. Due to the large number of places where properties may be advertised, it's not obligated to show any particular property. Isn't it sort of, isn't the whole point of this that, that the compensation was advertised and people were not showing properties or they weren't getting paid enough? Then does that open that up again, or what's your thoughts on that? I read that and that one sort of shocked me that it's in there.
Well, no, it's saying if it's not available, right? You see the last part.
That is available.
Unless buyer requests brokerage use in writing and the property is available for showing by buyer's designated agent. Meaning, say there's a property that's advertised, but how do I explain it? Say this property is advertised, and I don't know, maybe it's on temp or something, temp status, or there's an issue. You know what I mean? Yeah. So, but gotcha, you're asking a different question, I think. Right?
Yeah. Okay. So this is more so like if I, as a listing agent, am not allowing things to be shown by buyer's agents, then maybe you're not obligated to show it. But if I am allowing you guys in, then you should be showing it. Okay.
Yeah.
Okay. Cool.
Meaning, don't hold me liable because you saw something advertised and I wasn't able to show it to you. I think that's the gist of that.
Gotcha.
Right?
That makes sense.
Yeah.
Okay. I think that unless there's anything else you want to say on the buyer's agreement, I think that covers that one for me.
Okay. Do you want to look at this 13, these 3 options of terminating this agreement? Because I think this is kind of, so you can either terminate it by mutual agreement, which means both parties, the buyer and the realtor says, all right, this isn't working out. That's it. The termination by buyer, where the buyer says, hey, I don't want to use you anymore, or I'm not buying anything, so I want to get out of this. I signed this for 6 months, but it's been a month. I don't want to do this anymore. And see in that option B, you can put an amount there, right? Yeah. So as a buyer's realtor, say you put $500 in that line. The buyer terminates us before the agreement terminates on its own and expires. They'll have to pay you that amount with a brokerage, right? Now, it says services prior to termination and reasonable expenses. Who knows what that is? It's not defined anywhere. So you might say that's gas in your car. I don't know. You might say that's coffee you bought. Whatever it is. But if you put that in there, your buyer's going to pay you that. Supposedly.
Gotcha.
Right.
What if is there anything, since we're on that, what if the brokerage terminates? Is there any,
that's an interesting
any penalties to that?
So that's C. C is termination by brokerage. And people might wonder, well, why would that happen? This will only happen, it says, for a buyer breach. So if we think about this in practical terms, it's kind of a tricky one. So if the brokerage says, okay, You got an agreement with our realtor. You went and showed a property. You wrote an offer. Now you walked away, right? Like say the buyer disappears. Okay, so the buyer did everything right. The offer accepted. Buyer doesn't close. He just doesn't show up at the closing, right? This says the brokerage. Let me see. They'll calculate. It says it's interesting how it's worded. We talked about this in the meeting, and I'm not saying I disagree with this wording, but it's an interesting wording. Buyer and brokerage agree that calculating brokerage's actual damages may be difficult. Therefore, buyers shall pay to brokerage within 5 business days the acquisition commission as defined in paragraph 11, or the hourly rate, to compensate brokerage for time, expenses, and services. All right. The acquisition commission, if we go back here, that was the percentage you put in there. So that's the whole 2.5%, 3%. So you got a situation there where a buyer walks away, and this is saying the brokerage is due the whole, say on a $400,000 property, 2.5, the whole 10 grand. How is that going to be collected? I'm very curious. But as they said, that's not a problem. But I don't see that how that's going to be collected. It'll be
interesting
and legally speaking.
All right. Here's my question for you. What's a buyer walks away? We're about to go to closing. Buyer walks away, and this is sort of a joking question, but a serious one. Or you can answer it seriously. But is the seller more likely to keep the earnest money, or is the buyer's agent more likely to get paid?
The earnest money. Yeah.
Earnest money thing? Okay.
Yeah.
But I think almost. I think once I've seen earnest money attempted to be kept.
I didn't hear you.
No, I said sorry. I said I think I only saw like one time in my career where earnest money was even attempted to be kept by the seller.
Okay.
Most of the time it goes right back. But
no, I've seen several. I'm running into several where they're saying, "Oh, we're not giving that back. You're outside your contingency," and that doesn't mean you get it back. It just sits at the brokerage now because nobody knows what to do. Well, the other attorney walked away. Every attorney walked away. Now what?
Yeah. Oh, I want to. Before actually, let's jump into this first. I'm going to skip around a little bit, but let's talk about how now, as a seller, if you're listing your property, you pay commission. Because I'm not going to lie, it sort of seems like it's just a lot more pages to say the same exact shit.
Okay, let me pull up. I don't have it right in front of me.
Yeah.
So if you want to go to a specific part on there, we can.
Yeah, if you want to just go to part 11.
Okay, let's see.
The brokerage compensation.
Are you on the car listing or on the multi-board?
Yeah, car.
Okay, car. Let's see. Right to sell. All right. 11, you said?
Yeah.
All right.
Brokerage compensation.
It's a lot. These are the options here. So the first one, you can do the gross or net, right?
Yeah. So
that's a whole other discussion, right? That never came up before, the whole gross and net thing. Where was that ever disclosed at? So at least that's on here, which is good.
So first of all, I want to say part A, right? When you're signing these agreements as a whether you're a broker or if you're the seller, right? Just to think about. Part A is just the commission that is going to be kept by your broker that is listing your property. So, if you think that if in your mind you were going to pay 5% last week and now the new rules are in, then you'd probably, be somewhere between 2 and 3% to the listing side, depending on what you're negotiating.
So the listing agent only.
Yeah. So you don't want to, if that number is 5 or 6%, and again, you pay, if it's worth it, pay it, but you're probably paying too much in my opinion, if you're trying to pay 5 or 6% just for the listing side, because it's no longer split now. And again, there's an option for flat rate and things like that, which has always been an option. There's flat rate companies all over the place. There's different ways to do it. But what I want to go down is jump to 12, which is talking about the compensation to the buyer's agent. And this is something that's very interesting because they can't advertise it on the MLS. They can put it on their own website. They can do other things, but they can't advertise on the MLS. But there's going to be a couple of ways, and I'm curious to ask you this one first. We'll talk about the third option separately, but between option A and B, one is the brokerage pays the buyer's agent, and the other one is the seller pays the buyer's agent. why would that matter? Like, what's the difference, or why logistically does that matter?
There's a nuanced reason for this, and we went over it for hours and in the committee. And I didn't know we were going over this right now, so let me try to remember this. If we look at the bold print on each one, that's kind of the difference. So one comes out of the brokerage, one comes directly from the seller, and the reason it matters is something to do with dual agency, and if the realtor, or not even dual agency, say you and I work both for Coldwell Banker, the same brokerage, and how that works, right? So one can come from the seller, one may be internal from our own brokerage, where the buy and seller's agent are working under the same company. Does that make sense? See the bold print here? The procuring broker, look at A. The procuring broker may be part of the brokerage if the buyer is represented by different designated agents. Seller agrees to pay this additional commission regardless of any agency relationship. The other one at the bottom says the procuring broker may be part of the brokerage. Buyers are by different agents. Seller agrees to pay the additional commission regardless seller brokerage margin. So there's a nuanced reason for that. On one will come directly from the seller as a check. The other one will be a lump sum at that brokerage. So, like, say you and I both work at Coldwell Banker, and it'll be split through that. Yeah. It's just a mechanism. And I also, we kind of played with this for a while. And there was difference of opinion on this, and this is the best that we came out with. It's a little confusing, but I think there'll be more direction from CAR on which one you use when. Because you're right, there was a realtor now, when you look at this, it's going to be a little bit challenging to figure out why would I pick either, which one I pick, right? Mm-hmm. But it's a mechanism on how that commission flows. And attorneys should be well advised on this as well, doing closings, because the way commissions work now, as you know, the listing agent has the commission, right? The whole commission, and they're dispersing the commission through the title company. It's nothing to do with the buyer's brokerage. They get the check. They give it to the buyer's realtor. The way this could work could be different. The seller itself could be sending the check through the title company to you, right? To your brokerage. And your brokerage could be the same or different. If it's the same, there'll be one lump check. And I'm seeing a lot of confusion at the title companies already on this. And the closers are asking me, how do you want the check? Do you want one check to go there, or do you want to come here, split it? How do you want it? Do you want to put the little extra part?
If you're writing a...
So
I gotcha. If I put your... And I know you said that some more info is going to come out and we'll get some better clarity, but if I'm signing a listing agreement today, which one would you... Which one would you think I should check as a broker?
Now watch this, Tim. Here's the solution. Look at line 162. Check all that apply.
Yeah. Okay.
So you can check both.
Okay. Let the attorneys figure it out.
Yeah, figure it out. So that's why I put that in there. That was the wrinkle on that. So yeah, you can do all. And you do the unrepresented, and you do the other one too. The other.
Yep. So let's talk about that one. Unrepresented, and that's the third one. If a brokerage and designated agent prefers a buyer or tenant for the property that is not represented, they'll pay a commission. So what does this mean? It means that we can get back to the same exact spot where we were at, where you do 2.5 on one side, 2.5 on the other side. And even if the buyer is not represented, you are still going to pay the full 5%. And I sort of have a feeling a lot of brokerages are going to go that way. Because it's basically a lot of paperwork to get to the same point.
You have to have your seller to agree to that. The seller might say, what am I going to give 5 for? Tell the buyer to pay that. If they're unrepresented, okay, fine, unrepresented. Well, I'm not giving you 5. I think that knowledge is not out there yet. It might take a year for that to happen. But when the sellers, the homeowners, the average homeowner figures that out, that's what's going to happen. I think.
Yeah. And again, this podcast is, and I know we have a lot of realtors that listen to it, but obviously this is a podcast for consumers. So it's something to, again, the top of these contracts say, negotiate. If your agent's coming to you and wants the listing and is making you check that box, it may be worth arguing with them and getting them to uncheck that box. Mm-hmm. That's 2.5%. And I think we mentioned this earlier. We're going to see more. And we can spin this any way we want, whether it's a good or bad thing, but we're going to see more unrepresented buyers because of this. So,
especially if you look at younger buyers, right? So if I look at individuals such as a lot of my cousins who are younger than me, put it that way. For people in that generation, I think it's Y or Z or whatever generation is, They're used to doing things on their own. I just talked to a guy the other day at this event. He says, "Yeah, I bought my car through Carvana." I said, "What kind of car do you have?" "Oh, Mercedes S." I said, "What? You bought $100,000 vehicle called Carvana?" "Yeah, I bought it and they delivered it to my driveway." I said, "Are you okay with that?" He said, "Why wouldn't I be okay? It's got a warranty through it." This is the model, right? So if people can buy a car like that, certainly calling a listing agent, viewing a property, and writing out that's not far fetched, you know.
It's not. And you know what? And I completely skipped this part because I wasn't going to bring it up and we didn't. But I would say the one difference would be that they make 100,000 Mercedes S's and they're all exactly the same off there.
They're the same. You know the exact product and you know the exact
product. Whereas every house is different. Now, I'm going to jump back though and sort of debunk what I just said, because in the buyer's agreement, there's literally a clause with car that your agent is not responsible for knowing anything about construction, anything about title, anything about that, which I think is sort of, I get it, but at the same time, like, I think agents should know some of that stuff and should be able to tell you that your furnace is 20 years old and it's going to die soon.
Yeah,
but again, that's
you can add that knowledge. But think about this. Depending, like we said about the vehicle, think about the product you're looking at. If you're a purchaser of a 1-bedroom condo in River North, right, and you have a realtor say, I want to be south of Chicago Avenue, north of Grand Avenue, east of the lake, or no, I'm sorry, east of like Michigan, west of, let's say, LaSalle or Clark, okay? And I'm buying a 1-bedroom condo and I want a building with a swimming pool, okay? And I want a balcony. That's I'm not saying it's an easy thing to do as a realtor, but that's a very specific criteria that you'll pull up about 118 units or something, right? And you can sort by price. And I can know which building. Okay, now I'm down to 2 buildings. I know I only want to be in this building. Now, which floor do I want? Which tier do I want? There it is. There's the product. It's not so different, right? Maybe the appliances are different. That's very different than an investor that says, I want a 2-unit that brings in XYZ. I want to be in this area, these 2 neighborhoods. I want to be, So, as a consumer, what you need. As a realtor, you should also know what you bring, right? Am I just going door to door, like in doorman buildings and showing 8 units in one building? Maybe that's not adding a lot of value, right? So if your client says, well, I don't know why I got to pay you an extra 2% on top of this 2 you're getting, maybe that's fair. You make that decision in your business model. Okay, yeah, this was a simple thing. It took me one Saturday and I'm making 10 grand. That's a good enough commission. But if you're showing an investor client 30 units over 2 Saturdays, in Englewood and South Shore and driving around, try to look for parking, try to open doors with drills, maybe I should get 4%, 5%. You know what I mean? Like what are you bringing? What is your worth there?
Yeah, no, I agree. Now, the last thing I want to talk about on the commission part and all that, there's sort of and maybe I'm reading it wrong. You tell me, but I think a loophole to all this that's in this contract. So one of the big things is MLSs cannot put on the buyer's commission and advertise it. Well, now we have the seller authorized closing cost credit. So a seller can authorize to advertise a closing cost credit. And I guarantee those credits are going to be 2.5 to 3% magically. And they're going to be in the MLS to the buyer saying, hey, we're going to give you we're offering a 3% credit. Am I misreading that, or is that just going to turn into a loophole at some point where, hey, I'm not going to offer any commission to the.
Certainly could write in the listing agreement, whether in the agent remarks or the public remarks, seller to provide 3% closing cost credit. There's nothing wrong with that, right? That's been done before. Now, if you're saying, I think what I'm hearing is, if you amend that line to say seller to offer 3% closing cost credit to reimburse or provide compensation.
You can't say that.
You can't say that. I don't think you can say that.
But it says in there, which closing cost credit may be used by a buyer of their choosing to compensate the licensed real estate broker. So if I'm a seller and I want to make sure that agents are coming to me or choosing my place, and I know, yes, brokers aren't supposed to discriminate. They're not supposed to push one way or the other, blah, blah, blah. But this is just me. If I'm selling, I'm checking off not paying any commission to a buyer's agent. And then I'm going to check off offer and advertise 3%.
Yeah.
Or 2.5%, whatever that is, because then you're shouting out Yeah, you're shouting out to the buyer's realtor that, hey, I have this commission for you.
You're shouting that out, but that's going to be the buyer's decision to say, wait a minute, like, I might want that credit for my closing costs.
They can take it, but I mean, and again, that's going to be the thing.
Mm.
You offer 2.5%, and if you're a savvy buyer that talks your agent down to 1%, now you're going to see 2.5%.
Yeah.
That's a 1.5%. And I think that's where, again, going back to that, I think that's where we'll see some of these price drops. Not necessarily in the actual price, but in these closing cost credits, things like that. That we'll see the net cost of housing go down, even if the gross cost doesn't.
Do you think that Fannie and Freddie Mac and such will allow for financing of commissions ever?
I think they have to eventually. I just think that it is, if you're HUD sitting here and talking about fair housing and how unequitable it is to be a minority because you don't have the chances, and you've been pushing for the last 10 years all of these grant programs to help you become a first-time buyer and all this, but you're not going to, and maybe that's how they'll do it. Maybe it won't actually be in the loan, but maybe there will be a grant that comes out and says, hey, if you make less than $100,000 a year, we're going to pay 3% to your agent as a grant. So maybe it's that way and not in a loan, but I think,
okay.
And not that I'd be that surprised if the government talks out of their ass, but I think that as much of a push has been to get equality and to get people that have had less chance to buy homes to be able to buy homes, I think it'd be a disservice that they're not voting something like that in.
That's only if we view this new settlement to be an impediment to a lower income or first time home buyer buying a house, right?
100. I mean,
I don't know if that's quite.
I think it 100% is.
Is it? Yeah, I don't know.
I mean, unless, and again,
that's probably
it's a lot of.
I'm not sure how that will shake out. I'm not sure, because I think a first-time home buyer can still go unrepresented to an open house and a lower income neighborhood and put an offer on a place. I think it happens all the time, right?
It does, but also, but at that point, you're talking about someone that's not college educated, and I'm not saying all of them. I'm just saying the people that we're talking about that are lower income. It's probably because they don't have a master's degree or a college degree. So we're talking about people that aren't as sophisticated, and unfortunately, and we manage on the South Side. We see it all the time. We see people run scams. I've had calls from people that bought properties from overseas, and these are people that are millionaires in Dubai, and they're getting scammed by these people on the South Side of Chicago because buy this building, it's great. Here's a bunch of photos, and the building's burnt to the ground. So there's unfortunately, the way the world works, I think there's going to be too many people trying to take advantage of those buyers and selling them wool over their head or whatever that phrase is. That I think that it's whether it stops them from buying or just puts them in a worse spot. I'm not sure yet, but I think there's going to be a lot of bad advice. When you come to me unrepresented, trust me, your 5 days is going to run out. If you're not sophisticated, I'm not going to sit there and remind you, hey, did you call an inspector? I want to make sure your earnest money's in on day one before I go find another buyer.
Of course, yeah.
But I'm not telling you, hey, you have 5 days to get an inspector. Oh, that's 6 days. No, your earnest money's mine, or you buy the building.
It's over with. Yeah, you're right. So you're saying there'll be more of that. Yeah, right. You're right. Yeah.
Because I mean, I've seen other agents. I've seen other agents on TikTok talking about representing sellers, and 100% it's their job. Like if you're a seller paying me 3%, the reason I'm charging 3% is because I'm going to cripple someone that comes in unrepresented as a negotiator. I'm not going to bring up the inspection. And then when they go, oh, I heard I have to get an inspection, I go, well, that was 10 days ago.
It's too late, right?
Yeah, it's too late. Yeah, hopefully they get a good attorney, but there's a lot of just as many bad attorneys as there is bad realtors.
I hate to say that, but there's attorneys that miss contingency dates all the time. They blow right through them. They don't even write the attorney review letter. I say, okay,
I mean, it's crazy. I got one more thing on this contract I want to talk about. I don't think it has anything to do with the lawsuit, but it's a very interesting clause that I saw. But the love letter.
Oh yeah.
I think that's new at least, but
I think that was implemented like a couple of years ago. No.
Okay. So we've had it there, but that's an interesting thing.
Car's position on it anyway.
If you're a seller, I mean, what's your take on that? On getting those letters or not getting those letters? What's the risk of getting them? Talk a little bit about that.
So I know there's, I don't see it too often anymore as of this year and last year, but before that, 2 years ago, there's, I think, two different realtors that I work with who tended to use these quite a bit, right? So they put offers in, they have their clients write this story about how they grew up in the area and they're moving back and they're near schools, they have two little kids and it'll be a beautiful home. They can't wait. Look, I don't know how effective this is. I don't know if this works. Apparently, they say it works sometimes. Some sellers are emotional and they, but look, this is to me, I think it's a big, big issue when it comes to fair housing. So you cannot make your decision on to sell a house whether you thought it was a cute couple with a cute baby. This isn't going to work, right? So what are we using this letter for? I guess we're adding it to add additional information that can't be conveyed on this contract. But the problem is, this is the contract. This is the information to go by. Anything else, you're getting into muddy waters in terms of any kind of discrimination of any sorts, right? You got two offers come in, same price, waive contingency, waive inspection, same closing date. How are you making your decision now? If I'm the seller, I don't want to make my decision based on this letter that says, blah, 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 blah. Maybe I'm discriminating with people without kids. Maybe I'm discriminating against an investor.
And check out, go to showstylemanagement.com, check out the blog. So look for,
what is it?
For the blog about our website, chicagostylemanagement.com.
Right.
But if you guys go there onto the blog side of things,
that would
have a letter to I wrote, because they just come out with what is discrimination. So Congress last year passed new laws for fair housing, but they were very they didn't say much. They were very vague. So HUD had to write clarification, and it basically comes down to that you don't have to feel like you don't have to discriminate to discriminate. If you're doing things,
it doesn't have to be your intention to discriminate, is what you're saying.
It doesn't have to be your intention. Thank you. That's the way to say it. So I think let's say everything is pretty close, and you choose one of them, and you flip a coin, but they somehow find out that you read a letter, and that family was X race, and the other family was Y race. You're open up to liability that's going to be very hard to get out of. That if they sue you or something like that, it's going to be really hard to get out of. So even on rental applications now, like just asking the question, "Are you married?" is discrimination. Whether you use that or whether you're not using that in your decision, having that on there is discrimination.
It's not relevant. Why am I basing my decision based on that? Yeah, that's not relevant.
Yep. Exactly.
But, I mean, this is interesting, cool, especially in neighborhoods you work not to target their neighborhoods, but say Inglewood and West Inglewood. They're going through a significant change right now, racially and economically, right? So I'm running into situations where I have clients. To be quite frank, I have clients who are Black and I have clients who are Hispanic, who both are investing in Inglewood heavily, okay? And I have clients who are white that are investing in and that are Asian, quite frankly. But when it comes to these properties that are occupied by owner-occupants who have been there for 60 years and 50 years, and they may have a porch violation and they may be having a hard time to keep this property up, and they want to sell it. The way they're making decisions on who to give this property to, I believe some of it constitutes discrimination. And I've run into a few times here where I've had proof of funds and cash offers and I haven't been accepted. And I haven't really, filed arbitration or went to a claim on it because I don't really think it's that much of a good use of time. But I will say that I don't think it's right. You know what I mean? If you get an offer and it's a cash offer, whether that guy's an investor who lives out of state or whether he is somebody who lives in the neighborhood, that's an offer, right? And your decision and the realtor's guidance should be based on that document, right? The realtor should not be guiding you based on, well, he has 42 other properties and he's going to just tear that porch down. You know what I mean? It should be based on what's on that paper. And I think realtors are doing a disservice to their client, and to their own license, if you're going to make decisions based on other information. And it happens all the time. You know that. The whole neighborhood is talking about an offer, the whole block.
So absolutely. I lived in Pilsen. My wife's family grew up there, and we were there for a while, and we saw that there with gentrification and things like that, and trying to slow down gentrification. So it absolutely happens.
I'm not against that either. Like, there's some merit to not having a neighborhood be gentrified very quickly and destroyed. Destroyed in the sense that where people don't even know what's happening. Next thing you know, they've lost their property because they didn't know they had to pay this or that. So I understand there needs to be more knowledge on that, but when it comes to discrimination, like you say, writing these letters, I advise realtors not to do it. I think it's kind of an odd practice. I know it happens a lot in the suburbs. That's it's a little different, but I think make the decision based on the offer. Not whether they love the swing set in the back and their kids can't wait to play on it, and we support having a family. We don't believe in single people buying stuff like this, right?
I get it. Cool. So we're about to come up on almost an hour here, so I'm gonna start wrapping it up. But any last thoughts on the agreement, on the settlement, or on the new way things are going to start going here mid-August?
I think the best thing on my Instagram, I made a post on if any realtors are confused on this, they can do a 30-minute consultation with me. And as an attorney, I can just explain at least the legal aspects of what you're going to be. So people are welcome to find me on there or attorneytosh.com. I do think there's a lot of confusing information coming out right now, whether it's from the media, whether it's from brokerages. I think CAR has done a great job on getting this form out now, early enough where we have at least, a month to review it. I know some brokers are not using it. They have their own internal forms. And as realtors, just talk to your brokerage and get the guidance from them on how to use this form. Don't just start walking around the field and using the form, you know what I mean? And filling out incorrectly, because will you be compensated? I don't know. You know what I mean? When you go, if the buyer says, oh, well, hey, look, you put on here, 60643, and now this property's not there. I don't want to pay you the extra 1%. I don't think buyers going to push back on paying whatever seller's paying. I don't think they care, but I can't pay you the extra 1.5. Fine, to have a transparent conversation. Don't just shove this in front of them and say, you sign this. Let's go look at property. Because you want to build these clients for life, right? You don't want them to, they're coming to the closing and saying, I didn't want to pay that extra $2,000, $3,000. I didn't. Oh, you didn't talk about this? No, I didn't talk about this. And I'm the attorney. The realtor's not even there. I'm in a bad position. And so, well, here's the form. Like, here it is, So have a transparent conversation, show your value. And I believe the realtors who do that will still be in business. They'll still do a great business.
100%. Tosh, I want to thank you again for coming on. You have distinguished honor of being the first person to be on this show twice. So
the third time we'll each bring a special microbrew, and we'll have a review at the end.
There you go. Perfect. Awesome. Cool. Thanks everyone for listening. We'll see you in the next one. Like, subscribe, do all that stuff. And follow us. We're on Instagram at The Landlording Show. And Tosh, you want to give yours out really quick? I know you mentioned it. Your Instagram handle
is attorneytosh.com. So TOSH. Attorneytosh.com. You can book a consultation on there. Most of the flat fee services for your clients will be on there as well. And the rates are on there. If you want to go to my Instagram, it's agenttosh.com. It's how I had it when I was a realtor, and I still have it on there. I don't practice as a full-time realtor anymore. It can't be two things full-time. So I practice law. I do represent certain investors on purchases and sales and other family and friends.
Thanks, Tim. We'll see you guys all next time.
Thank you.